My name is Josephine Achampong, and I am 60 years old. I spent 21 years as a licensed financial planner, estate planning consultations, trust structures, asset transfer strategies, the specific work of helping families understand how wealth moves from one generation to the next and what happens when that movement is not planned carefully. I know what a revocable living trust is. I know how it is funded, what it controls, what it does not control, and exactly what happens when an asset that should have been transferred into the trust was never transferred, when the trust exists on paper, but the property it was meant to hold was never retitled into the trust's name. I know the term for this. It is called an unfunded trust. And an unfunded trust, with respect to any particular asset, controls nothing. I knew all of this. My mother-in-law, Cecilia, was a woman I had loved and been close to for 31 years. When she died, she had a revocable living trust that her attorney had prepared 8 years before her death. The trust named her son, my husband Bernard, and me as equal co-beneficiaries of the family home, which had been in the family for 40 years and was valued at approximately $480,000. Cecilia's daughter from a prior relationship, a woman named Yvette with whom I had a formal but never warm relationship, produced a claim 18 days after the funeral. The claim was simple. The house had never been retitled into the trust. The deed still showed Cecilia's name as sole owner, which meant the house had not passed through the trust. It had passed through the estate, subject to probate, subject to intestacy, and as a daughter, Yvette had an intestate share. She was right about the technical failure. The house had never been retitled. She was not right about the outcome because I had been a financial planner for 21 years and I knew that technical failures in trust funding do not always produce the result the challenging party expects, and I knew exactly where to look for the evidence that would determine what result they produce. Welcome to Calm Drama Stories. My name is Josephine, and this is the channel where the knowledge you spent decades building becomes the tool you reach for when everything else is uncertain.
Subscribe.
Leave your city below. This story begins with a deed that was never retitled and ends with a probate court finding that honored what Cecilia intended. And between those two things is a doctrine called pour-over, a piece of evidence called a certificate of trust, and 21 years of knowing how estate plans work when the paperwork is imperfect. Let me tell you about Cecilia first. Cecilia Achampong was 79 years old when she died of congestive heart failure. She had been a retired schoolteacher, patient, organized, a woman who had understood the importance of planning because she had watched people she loved leave nothing organized behind them and had decided she would not do that. 8 years before her death, at 71, she had hired an estate planning attorney and created a revocable living trust. The trust was designed to hold her assets, primarily the family home, and distribute them at her death equally to Bernard and me. What should have happened next? The attorney should have filed a new deed retitling the property from Cecilia Achampong to the Cecilia Achampong Revocable Living Trust. This is called funding the trust. Without this step, the trust is a structure without its intended contents. It did not happen. Whether the attorney failed to advise Cecilia to do it, or whether Cecilia was advised and did not follow through, I do not know. The deed remained in Cecilia's name for 8 years. When she died, the house was technically outside the trust. Yvette's attorney knew this. He had done his research before the conversation. I did not panic when I heard the claim. I went in my files. The first thing I looked for was the pour-over will. Most revocable living trusts are accompanied by a pour-over will, a document that says, in effect, any assets I owned at my death that are not already in the trust shall pour over into the trust and be distributed according to the trust's terms. It is a safety net designed precisely for situations where an asset falls through the funding process. If Cecilia had a pour-over will, the house, despite not being retitled, would pour into the trust at her death through probate, and the trust's distribution terms would then govern it. Equal shares to Bernard and me. I called Cecilia's estate planning attorney, a woman named Patricia, who had drafted the original documents. I introduced myself, explained the situation, and asked, was a pour-over will executed as part of Cecilia's estate plan? Patricia checked her file.
She said, yes.
Cecilia signed a pour-over will on the same day she signed the trust document. I have it here, I said. We will need that document filed in the probate proceeding. She said, I'll have a copy to you today. Yvette's attorney had anticipated the pour-over argument. His counter was straightforward. Even if the house poured into the trust through probate, that probate process was subject to Yvette's intestate claim as a daughter. Before the asset could pour over, it had to pass through the estate, and as an heir, Yvette had a right to her share of the estate. This is a real legal argument. The pour-over will get the asset into the trust, but it does so through probate, not around it, and creditors and heirs may have claims against the estate during that probate process. I knew this. I had explained this scenario to clients. What I also knew was that the strength of Yvette's intestate claim depended on whether Cecilia had other assets passing through the estate that Yvette could be satisfied from, and whether the equitable intent of the trust was strong enough for a court to consider a doctrine called constructive trust, which allows courts to honor a clear intent to transfer property even when the technical transfer was not completed. What I needed was evidence of Cecilia's clear intent. I spent 2 weeks assembling it. The trust document itself, which named the house specifically as an intended trust asset in the schedule of property, even though the deed had not been retitled. The certificate of trust that Cecilia had signed and that her bank held, which referenced the family home as trust property. A letter I found in Cecilia's files, written in her own handwriting 7 years before her death, in which she described her estate plan to a sibling and said explicitly, the house will go equally to Bernard and Josephine. I also found, in Cecilia's papers, in the folder she kept for important documents, a note in her handwriting with Patricia's name, the trust's name, and the words transfer house. Ask Patricia. She had written it. She had meant to follow up on the retitling. She had not done it. The note was not a legal document. It was a piece of paper with 4 words on it that showed what Cecilia intended to do. I brought everything to our probate attorney, a man named Samuel who specialized in contested estate proceedings. Samuel reviewed the package and said something I had said to clients in different words over 20 years. A court examining a contested estate is not only looking at the technical documents. It is asking, what did this person intend, and how clearly can that intent be established from the evidence? The evidence was clear. The trust document, the certificate of trust, the letter, the handwritten note. Together they established that Cecilia had intended the house to be in the trust, had known it should be transferred, and had not completed the transfer through a failure of follow-through rather than a change of intention. Samuel filed a motion arguing 2 things. First, that the pour-over should be honored, and that Yvette's intestate share should be satisfied from the residual estate rather than from the house. Second, that even if the court declined the first argument, the doctrine of constructive trust applied. The court should impose a trust on the property to reflect Cecilia's documented intention, preventing unjust enrichment of a party who would benefit from a technical failure that did not reflect the owner's wishes. Yvette's attorney argued that intent was not the legal standard, that the deed was clear, and that his client was entitled to her statutory share. The probate judge reviewed the evidence over a hearing that lasted most of a day. She was methodical. She asked specific questions about each document, what it showed, when it was created, what Cecilia had understood when she signed it. At the end of the hearing, she said, the court finds that the decedent's intent to include the subject property in the trust is established by clear and convincing evidence. The pour-over shall be honored. Any intestate claims against the estate shall be satisfied from residual estate assets. The property shall pass to the trust and be distributed pursuant to trust terms. Equal shares. Bernard and me. What I want you to know, if you have a revocable living trust, or if you are helping a parent create one, is this. A trust that is not funded is not protecting the assets it was meant to protect. Funding a trust means retitling assets into the trust's name. Real property requires a new deed. Bank accounts require new account titling or a beneficiary designation to the trust. Investment accounts require retitling. This work must happen after the trust is signed and before the grantor dies. Ask your estate planning attorney. Today, has every asset I intend to include in the trust been formally transferred into it? If you do not know the answer, request a funding review. Most estate attorneys will do this for a modest fee. Some include it as part of their ongoing service. If you are helping an aging parent who has a trust, the kindest thing you can do is sit with them and their attorney and go through the asset list. Confirm that each asset has been retitled. Do not assume the attorney handled it. The attorney may have prepared the documents and left the client to follow through, and the client may have intended to follow through and not done it. One action. Today, if you or your family has a revocable living trust, call the estate planning attorney and ask for a funding review. A trust document without its assets is a frame without a house. The structure is correct. The contents are missing. Check the contents. The house belongs to Bernard and me equally. We have not decided what to do with it. It is too soon, and the question of what to do with 40 years of someone's life is not a decision to make quickly. I think about Cecilia's note often. Transfer house, ask Patricia. For words on a piece of paper that she wrote with every intention of following through, that she filed in her important documents folder, that she never acted on. She intended everything correctly. The execution had a gap. I found a note that showed the intention, and a court honored it. I have spent 21 years helping people close the gap between what they intend and what the documents record. I did not close this one for Cecilia because it was not my plan to manage. It was hers, and she had her own attorney. What I could do, when the gap appeared, was use what I knew to find the evidence that showed what she meant, and to put that evidence in front of a court that was willing to look at the whole picture, and not only the deed. Know whether your trust is funded. Know whether the deed has been filed. Do not leave a note in a folder. Make the call. That is everything.